Hey Fiona, my name's Ari.
Hey Fiona, I'm Kasim.
And I'm Izzy.
And today we're going to talk to you about director remuneration. So, what is a director, you might be wondering? A director is an appointed or elected member of a board of directors who, with other directors, has the responsibility for determining and implementing a company's policy. So, Kasim, what is director remuneration?
Okay, so what is director remuneration? So both executive and non-executive directors may be compensated by fee, salary and the use of the firm's property as a matter of agreement between them and the firm. So why do different countries have different legal requirements? Izzy?
Different countries have different legal requirements because they all follow different legal systems. This presentation will focus on the UK, Germany and Hungary. We'll now start with the UK. Kasim?
Okay, so firstly, a little bit about the United Kingdom legal system and its background. So, the United Kingdom of Great Britain and Northern Ireland consists of 4 countries which each have their own court system and legal professions. These include England and Wales, Scotland and Northern Ireland. So in 1973, the United Kingdom joined the European Economic Community, which is now commonly referred to as the European Union. So since this date, it's been a legal requirement to incorporate European legislation into United Kingdom law. So the Constitution of the UK consists of both legislation, which is made up of statutes, and also case law, which means that judges can make decisions based on precedents by interpreting these statutes and also making a decision based on past cases. So as of 30th September 2013, there's a new style of directors' remuneration report which must be required. This is completely different to the old style report. So the remuneration report is now split into 2 sections, both the policy report and also an annual report. So first of all, the policy report, which actually isn't subject to any audit at all. So this contains details about the remuneration policy itself for the organisation. The policy report must show a table which shows each element of remuneration and also how it contributes to the firm's overall strategy. Furthermore, it also shows how performance is assessed and rewarded, and this must also include how the shareholders' views have been taken into account. Secondly is an annual report on remuneration. Now, the annual report itself contains some parts which actually are subject to external audit, whereas for the policy report it wasn't subject to any audit at all. Okay? Now, this includes details about what directors have been paid in the reporting period. The new remuneration reporting rules are based on proposals which were put forward in 2012 by the Department for Business, Innovation and Skills. So the main reason for the changes, there's actually 2 main reasons that these changes were implemented by the government. First of all, it gives shareholders more power through binding votes so that they can hold companies and directors to account for their remuneration. Secondly, it boosts transparency so that it's easier to understand what directors are actually being paid. Okay, so another new addition includes the requirement for a single figure for each director, both executive and non-executive. So this figure should include everything such as salaries, fees, benefits, bonuses, share schemes and pension benefits. So here's an example of the single figure requirement. So sections A to E would include different aspects of remuneration, for example, as salaries and fees, etc. And over here is a total figure, and this is the single figure requirement that they would require overall the total. Okay, so the current United Kingdom law states that under section 420 to 421 of the Companies Act 2006 of Schedule 8 of Statutory Instrument 2008/410, large and medium-sized companies and groups must actually disclose their directors' remuneration through the annual report on remuneration. Now, only companies that are quoted must actually set out this information and outline directors' remuneration and emolument packages within the directors' remuneration report. Now, this is actually produced by the directors themselves, and furthermore, it must be approved by the board of directors and also signed by the secretary of the company. Now, in case you're wondering what a quoted company is, it's defined under Regulation 10 as a company whose share capital is included in accordance with provisions of Part 6 of the Financial Services and Markets Act year 2000. They should also be listed in the European Economic Area state or trade on the New York Stock Exchange or NASDAQ. So therefore, any company which is listed on the alternative investment market or smaller companies are not actually legally required to publish a director's remuneration report, although they may actually optionally choose to do so. Okay, so how's this report actually constructed? So it's recommended by the UK Corporate Governance Code 2010 that a remuneration committee, which should consist of at least 3 independent non-executive directors, although for smaller companies this can actually be 2 people. So these are the people that set out the report. Furthermore, a chairman can be a member of the committee. However, he can't chair the committee himself, he can only be a member. So what do the committee do? So they basically ensure that the remuneration packages and arrangements are in line with the strategic aims and objectives of a business, whilst also motivating and retaining senior executives, and also ensuring that regulatory requirements are complied to. So the report is regulated under Section 439A of the Companies Act 2006, and as previously mentioned, quoting companies' remuneration policy is subject to shareholders' approval every 3 years. So the actual remuneration itself is down to an advisory vote. However, if this advisory vote is lost, the policy must be brought to a binding vote at the next annual general meeting. So although the policy is put to vote every 3 years, companies choose to do this more frequently, usually if they desire to do so through general meetings. So everything that I've mentioned over the last slide is as a result of the new rules which were implemented on the 30th of September. So I'm now going to hand over to Izzy, who's going to talk about the rules and regulations for Germany.
Just a brief summary of the German legal system. So Germany run on a different legal system to the UK, as they have their own German legal system. As a federal republic, the German courts are divided between the federation and the states. Federal law comprises of 3 different types of courts. So you have ordinary courts that deal with criminal and civil cases. You then have specialised courts that deal with administrative cases. And then finally you have constitutional courts that deal on judicial review and constitutional interpretations. State law is then responsible for all the lower levels of the court system. One section of German law features German corporate law. German corporate law distinguishes the difference between stock-traded companies and private limited companies. In corporate law, there is a mandatory separation between a management board and a supervisory board for both types of company. The management board consists of inside directors only under the section 76 of the Stock Corporation Code that states that management board direct the company under its own responsibility. The supervisory board consists of outside directors and appoints and supervises the management of the company. Similar to the UK, the German Corporate Governance Code is also a comply or explain law and features under section 161 of the Aktiengesellschaft. The German Corporate Governance Code was set up in 2001 and provides regulations and transparency for national and international investors and the general public. So, just a brief history of how the director remuneration was introduced in Germany. As I mentioned earlier, the Corporate Governance Code was set up in 2001. However, in 2003, similar to the reforms rules regarding transparency in the UK, the Corporate Governance Code introduced new disclosure recommendations for German listed companies, partly in response to the criticism that Germany received that they lacked transparency in comparison to the UK. In 2004, the European Commission recommended to all European countries that firms should disclose their director compensation. Germany then mandated this disclosure and legislated it in 2005 that all listed companies on the stock exchange had to produce their director remuneration information. In 2009, the Act regarding the appropriateness of the management board remuneration was formed, stating that shareholders should vote on excessive compensation to tackle excess remuneration. So, what are the actual German director remuneration regulations? Well, there must be individual disclosure of the compensation of directors of German listed companies. Under section 4.2.2 of the Code, remuneration on an individual basis on the management board should be determined by the supervisory board. Under section 5.4.5, the supervisory board's compensation is determined by the shareholders in a vote or by the company's articles of association. Disclosable remuneration includes salaries, profit participations, options and shares, fixed salary payments, long-term incentives, and expenses allowance, insurance payments, commissions, and fringe benefits of every kind. The total remuneration of previous members of each body should also be disclosed. Lastly, although the code does not have legal force, the German statute on transparency and disclosure implies that all German listed companies annually declare that if they comply with the code and give reasons for non-compliance. I'm now going to pass over to Eri, who's going to talk about Hungary and their director remuneration regulations.
Hiya, so I'm going to give a quick breakdown of the Hungary legal system. Essentially, there's a two-tiered board structure where the executive and the supervisory functions are split. However, since 2006, the Corporate Act allows a unitary, a single-tiered board structure in respect of NEATs, which are PLCs. Directors have full authority and power over a company unless the powers have been delegated to another organ of the company, for instance the members. Just like the UK, directors must give priority to the interest of the company and must exercise tasks with due care and diligence. The legal system requires disclosure of the aggregate sum on directors' remuneration, which is outlined by section 312/A of the Hungarian Companies Act. The Hungarian BSc Code of Good Corporate Governance in 2004 states that company boards of management must establish rules to the remuneration of senior management with final decisions made at the annual general meeting. Interestingly, the BSc also states that remuneration schemes are to serve the long-term strategic interests of the company and thereby those of the shareholders. There is, however, no evidence in the BSc of recommendation on transparency regarding remuneration. This is also evident in the Czech Republic and Poland, as found by Bergdorf and Pajute 2005. Regulations following the European Commission's recommendation is the Companies Act of 2006 and the Corporate Governance Recommendation 2008. So, how do you determine the level of directors' remuneration? It's important to note that the remuneration report is required as part of the annual report. The level of remuneration is determined at the time of their appointment at the general meeting of the supreme body. However, this is subject to the deed of foundation, just like the UK. The remuneration level is subject to the approval of the majority of company members as well. If you want to see the amount, you should refer to the members' resolution adapted for the election of the director to see the amount, which isn't set out in the Companies Act. However, there is an exception to the above rule. If the supervisory board of a limited liability company has the right to approve or remove directors, then the board can determine remuneration level without member approval. So as a continuation from the last slide, the remuneration structure must be as such not to impede the trustee's independence and effectiveness in fulfilling his mandate. Furthermore, the structure of the remuneration policy should be updated over time to ensure that it evolves as the company evolves and the financial market in which it exists evolves. An interesting note is that Hungary's transparency on remuneration is just 0.13 compared to the Czech Republic with 0.44. However, they're still better than Romania, who have 0, as found by Roderick Martin. Thank you. I'm now going to pass you on to Kasim, who will discuss the European perspective on executive remuneration.
Okay, so here's a European perspective on executive remuneration. So this table basically shows various countries along the top-hand side and also various elements of remuneration along the left-hand side. Now, as you can see in the United Kingdom, they've actually implemented almost every aspect of remuneration, including remuneration reports, policy statements, individual disclosure, approval of remuneration policy, approval of share incentive schemes, and also remuneration committee. Now, where this is different, if you look along the top, here's the countries that we've discussed. So we've got Germany over here, which Izzy spoke about, and we've also got Hungary, which Eri spoke about. So approval of remuneration policy has actually been implemented in the United Kingdom. So it's actually a requirement for shareholders to approve policy. As you can see over here in Germany and Hungary, this isn't actually the case. Furthermore, for Germany, a remuneration policy statement is required in the United Kingdom and it's also required in Hungary. However, in Germany, it's not currently required. And that's all on the slide. I'm now going to hand you over to Izzy, who's going to talk through the conclusion.
So, to conclude, in comparison to the UK, Germany and Hungary's listed company are required to have a two-tiered board system. All three countries do not try and attempt to regulate the amount of compensation payable to senior executives, as this is a matter really for the shareholders of the company. However, the three countries actually focus on ensuring that there is adequate information and disclosure towards the shareholders, so that the shareholders have sufficient information available to make their own decisions regarding the director remuneration. So here are our references.
Thanks for
Thank you
listening.
very much for listening. We hope you enjoyed it. Thank you.